So I will just share my screen and you'll be able to see the presentation. And we will start with a slideshow. So today we're going to have these are in relation to reporting requirements, and there have been changes on the reporting requirements because of a number of other rule changes and amendments. So the plan is for this to go for about 45 minutes and then have a bit of a Q&A afterwards. I'll do my best to keep to that time frame, and we'll see how we go. So the AER, the Australian Energy Regulator, has announced that it's reviewing its compliance procedures and guidelines with a view to improving the effectiveness and efficiency of the reporting regime. It's released a discussion paper, and throughout the discussion paper there are a number of questions that the AER is seeking stakeholder feedback on, and in this presentation I will be showing you screenshots of the questions commencing 1 January 2019, which basically gives us the rest of the year to get this into shape. And as I've indicated in the paper, it gives us a good indication of the likely time frame for these reforms. In releasing the draft amendments, AER Chair Paula Comboy is quoted as saying that they provide important new protections that are critical to ensuring customers are confident to engage in the energy market. It also will involve increasing the frequency of reporting in relation to explicit informed consent requirements. But on the other hand, it is intending to reduce the provisions which must be reported on in relation to billing. So in some areas there will be additional reporting requirements, might be additional provisions that have to be reported on, or increased reporting periods, and in other cases there will be less reporting that has to be done. And in talking about Paula Comboy, she gave a speech this week to an energy regulatory seminar. I've done an article in relation to that on our website. It's also on the AER website, and I think that it makes interesting reading in relation to the approach that the AER, and in particular its chair, takes to customer engagement and the way forward for regulation. Okay, so the scope of the review as set out in the discussion document is set out here, and as I mentioned before, it's to incorporate some of the new rules that have come in relation to life support, customer hardship and things like that. Refine the reporting framework to ensure it remains consistent with the AER's approach to compliance and the need to monitor compliance, and improve the quality of the reporting so that there is better information available for people. And again, referring to that speech earlier, she referred to a couple of reporting tools and some new reports that the AER is going to release with a view to really engaging consumers and customers, but also making the energy industry a bit more transparent in relation to operation and investment opportunities. Okay, so there are 5 key areas of reform in the proposed guidelines reporting. As I said earlier, life support, fixed benefit, explicit informed consent, hardship or customer hardship, and billing. So these are the main areas. There's a couple of other areas such as audit, reports and CEO, but these are the main areas. So what I'm going to do is have a look in a little bit more detail of each of these areas. Okay, so first the report provides a really useful summary of the proposed amendments. I won't go into great detail. You can all see that summary, and that summary is contained in the report as well, but it just gives you on a page an idea of the areas that they are looking to change. Okay, so life support is the first one, and it's, I guess it's understandable that the AER places emphasis or focus on ensuring that people that are on life support equipment don't suffer any loss of electricity, which could have a tragic consequence on them and their family. So as this slide says, in December, the AEMC made a final rule to strengthen the protections of customers relying on life support equipment, and that was in relation to retailers and distributors having to keep that information and notify those people so that it is very clear who are the customers that have life support equipment, and that procedures are put in place for any planned outage to accommodate those customers. So the proposed new obligations, and these sections, or rules I should say, are part of the new rules, 125 and 124B are in the new rules. And they have expanded requirements for retailers and distributors in relation to the registration of life support equipment and the records that are required to be kept. As I say on this slide, rules 124 relate to the retailer and 125 mainly relate to the distributor, but there are crossover requirements in both of those, and so this amendment is really just bringing the reporting requirements into line with the new rules that have been introduced. But with all these changes, of course, you'll need to be aware that if you have software or things like that, templates in relation to reporting, you will have to undertake a review of all those when these changes come through. So these are the proposed amendments in life support, and as I said, it's pretty much picking up the new rules that were introduced. As you can see, from this slide, the report has at the end of each section the proposed amendments and then the consultation questions, and these are simply asking what impact such a change would have, given that retailers and distributors will be required to comply with these rules. I can't imagine that reporting on them should be particularly onerous, but it will be interesting to see what the submissions are. Next one is in relation to fixed benefit. Again, this is November 2017 of change tracks. It required the retailers to send a notice to customers on the contracts in a specific time period. So the obligations under this rule are planned to be implemented in stages, which commenced on 1 February of this year. AER has published some guidelines around the fixed benefit rule change, and detailed information will be need to be required no later than 1 October 2018, and which most of us probably understand is not too far around down the corner. What is it? Round the corner or down the road, whichever one you prefer. So again, these are the actual proposed amendments. And again, it introduces some new rules and brings it into line with the rule changes. The consultation questions, and of course, although there are consultation questions, the submissions that people put in are not limited to answering the consultation questions, but the regulators usually use these types of questions to provide a bit of a guide to people who want to make submissions as to what are the issues that they're interested in knowing about. And again, it's really about if you're going to have to report on these various rules, should there be some consideration given to how frequently that reporting should be done, what obligations or additional burden would it place on a retailer in relation to reporting, that sort of thing. But as I said earlier, at the end of the day, all of these things are reporting requirements, so it should be that people are familiar with this. Okay. So the next one is explicit informed consent, which of course is quite an important issue, I would have thought. So the proposal is to move notification of all breaches of explicit informed consent from half yearly to quarterly, which means that there'll be more reporting on breaches of explicit informed consent. And you may be aware that the AER released information, I think it was yesterday, about Alinta being fined $40,000 for 2 breaches involving the transfer of customers across from another retailer to them without explicit informed consent being obtained. In the first case, involved a telephone contact, an agent of Alinta doing telephone sales, and despite the customer indicating to the telephone operator that they were quite happy with their current retailer and didn't want to switch, the telephone operator switched them. The second one involved a door-to-door salesperson going to the customer's home, having a conversation with them. Again, the customer did not indicate that they particularly wanted to change retailer. Following the visit from the door-to-door salesman, the person was contacted by phone by another sales representative of Alinta, and their account was transferred across. Again, without any clear, explicit, informed consent, or the customer even understanding that that was what was happening. I wrote an article on that, and as I said in my article, it's a good reminder for retailers who use agents that you have to be aware of what they're doing and whether they are following the requirements that you have as an exemption holder or an authorised retailer. You must make sure your agents understand those things. So as this slide shows, not only will it be increased in terms of the reporting from twice a year to 4 times a year, but they will also be expanding the rules or breaches which you have to report on. And as you can see, one of them is the correction of transfers without customer consent. The other is the record of explicit informed consent. It is very important to have a record of obtaining explicit informed consent. And as we've said in other webinars, explicit informed consent involves a conversation. It isn't just ticking a box. The customer has to be aware and told of what it is you are proposing and what the terms and conditions are of that a retail contract that you are proposing, whether they want to transfer, and it needs to be clear. It needs to be quite clear, A, that you've explained to them what it is you're proposing, B, that you've explained all the terms and conditions, and C, that that customer understands that and has agreed to it. I was surprised when I read about the Alinta one that having a customer say that they're happy with their retailer and don't want to switch could somehow be interpreted to, yes, I want to switch. I presume there must have been a record of the telephone conversation, and when AER listened to that particular transaction, it was clear that the customer had indicated the opposite of explicit informed consent. Now, along with the actual draft guidelines, the AER has released a notice of draft instrument, which is a really useful document, and you should have a look at that as well. It provides an explanation of the proposed rule changes and what's behind them. And I thought it was worth taking this quote out of the notice of draft instrument because it just highlights the importance of explicit informed consent. And as the AER says, compliance with NERL Part 2, Division 5, Section 40 is fundamental to proving that explicit informed consent was obtained before a customer transfer. This section relates to records of explicit informed consent and the obligations on retailers with respect to the format, creation and obligation to keep the record for a couple of years. Okay, so we have observed issues with retailers failing to retain records of customer consent. And so, again, if you're using an agent, it's important that that agent does keep the records of the conversations they have with the customers in relation to transferring or entering into a new contract. So again, this is the proposed amendments, as I said, changing the reporting requirement from half yearly to quarterly. And I think that that also provides the AER with the opportunity to have more frequent observation of the compliance with explicit informed consent. It certainly underlines a lot of the provisions that apply to retailers in relation to their interaction with consumers. And it is an important concept. And as we said, including additional sections of the Act on which they have to report on. So it's kind of a double whammy. Increased reporting period, which means 4 reports instead of 2, and additional rules that have to be reported on. And again, the consultation questions are about what impact these changes would have, and how retailers will feel about these changes. Again, it will be interesting to see what responses retailers make in relation to this area, because it is an area that requires people to keep records and report on, and it's fundamental that people shouldn't be subject to contracts that they aren't aware of, or I should say that they aren't aware they're entering into. So I would imagine that there shouldn't be too much pushback on this, but because it's increasing reporting, there may well be. So the next one is customer hardship. And as we all know, 2017, AER conducted a hardship review. As you may or may not know, when retailers receive their authorisation, they have 3 months in which to submit their hardship policies for approval by the AER. We've been involved in a few of these approval processes, and you know, the AER wants to ensure that hardship policies are easy to be understood by consumers, I guess, and that they cover all the requirements that a retailer or needs to have, or an exempt holder of an exemption needs to provide for their customers, because when you apply for the ombudsman schemes, they will usually want to have a look at your hardship policy too, because of course they are dealing with customers' complaints. And some of the complaints, of course, will relate to how people who are experiencing difficulty in paying their bill are being dealt with. So, as you can, as we know from the review, there are all sorts of different hardship policies and practices in place. The earlier hardship policies that the AER approved, I think, are a bit different to the ones that they are now approving, and I think they're requiring a bit more to be done to address customer hardship. Also, the AER is seeking to create an enforceable customer hardship guideline. E1 has a customer hardship template or draft, guideline, whatever, which is useful. The AER guideline, I presume, will be to provide a draft hardship policy which will contain the provisions and requirements that they think should be in a hardship policy. What interesting aspect in relation to how that cornerstone of hardship policy is allowing custodies, but another Sorry, I just had some technical problem then. Can you hear me now? I'll let Connor tell me, hopefully, that he can hear me again. Can you hear me? Yes? Yes. Okay. So I will go back to sharing my screen. And I was talking about the customer hardship practices. And I was just saying that we all understand about the payment plans, but there are some other requirements or issues that the AR is looking at in relation to hardship, and that's having discussion with customers about their energy usage or just got a complete blank. What a moron. Anyway, it's about efficiency, energy efficiency, and having things like LED lights, using appliances that take up a lot of energy in off-peak or low-peak periods and things like that. Also, it's about dealing with financial counsellors if that's where the customer has gone. So customer hardship, in my view, is a pretty big ticket item for the AER, a bit like the life support, and I think that we will see a bit more movement in this area, particularly as part of the overview of the framework that we've had. Particularly in relation to the review of the regulation for embedded networks and embedded network operators being part of the ombudsman schemes. I don't know if you saw the article in the paper yesterday about embedded networks and things. So, I do think that there is more attention being placed around customer hardship, how retailers and embedded network operators deal with their customers, and what rights those customers have. So, be an interesting space. Okay. So, the proposal is to expand the reporting requirements to include Part 2, Division 6, Section 44, which sets out the minimum requirements for a customer hardship policy and some other rules. And as you can see on the screen, they relate to the communication of hardship policies. Hardship policies should be available on websites, but they should also be made available to customers if and when they need them, but they should be available on the website, so a customer doesn't even have to ask for the hardship policy. They should just be able to access it on the website. As I said earlier, payment plans, that's probably one of the main procedures that's adopted to assist customers in financial hardship, which breaks up rather than a one big bill, they'll be paying over time. But of course, it's important that the people you have in the customer hardship team dealing with the customers understand or are realistic in setting up payment plans. Has to be something that the customer is able to afford, and not some unrealistic payment plan that is simply going to be breached within 1 or 2 instalment periods. Waiving late payment fees for hardship customers, and allowing payment by centre pay. In order to have centre pay, Centrelink, all those payments, you have to apply to be registered within that system. But it is something that you need to be able to provide to customers. So as you can see from this is the proposed amendments, adding additional sections to the reporting obligations. And again, the questions are what issues arise for retailers in relation to these additional reporting requirements. So billing, as I said earlier, instead of increasing the requirements around billing, they have decided to reduce. This is largely based on the fact that the AER could see that there weren't really breaches in relation to these other rules, and they were not very often reported on, and therefore it was decided that there should be greater clarity around what you have to report on. And given that there's a lot of things you have to report on, it is better to reduce that if it's not necessary, given that they are increasing it in other areas. So in relation to billing, it will actually be less items that you will need to report on. And I don't imagine that there will be much pushback from stakeholders in relation to the proposed changes to billing. Another proposed change, and they originally had 2 templates and then they went to 1, so now they're going back to 2 pro forma report templates. So B1 will be used for immediate potential breaches only, and B2 will be used for the quarterly, half-yearly and nil return reports. And as I've put here, the B2 form allows for a checkbox format so that businesses can checkmark the appropriate box. It's about streamlining, making it a little bit easier for companies to do their reporting and comply, and provision for nil return reports as well. If you go and have a look at the draft guides and regulations, they will provide links to the new templates for you to have a look at. Again, I don't know if there'll be much pushback in relation to the templates. They're 2 quite different ones, one being for immediate breaches and the other being for the regular reporting. We will wait and see. Here's another new thing, and again, in the speech that Paula Comboy gave that I referred to earlier, one of the things or themes, if you like, in her speech was the responsibility of the board of directors in relation to compliance and regulation, and with customer engagement and understanding what the customers want and really leading from the top down. And I think the engagement of the CEO in the sign-off on the final audit is all part of this accountability, if you like, that the regulator expects the top to the bottom to be compliant. It isn't enough your managers and the staff to be compliant. It must be coming from the very top. The board, senior management, they all must be aware of the compliance procedures and foster an environment of compliance and engagement with the customers. So they will require the CEO or managing director to sign off on the final audit report before it is submitted. It'll be interesting to see what the feedback from stakeholders is on this one. Then there are around the audits. Specific audits, or tax audit or any other sort of audit. And so having clarity around it, having business able to understand the process is probably a very the submissions. They will come out and provide feedback in relation to their proposed amendments, and if they are going to change anything based on feedback. So, as I referred earlier to articles, we provide a number of articles on our website under news. So you just have to go to www.compliancequarter.com.au. I think that's right, and Connor will tell me if I'm wrong. Anyway, so that's us here. Connor's email and my email, and I will escape from my PowerPoint because then I can see if there are any questions. Does anyone have any questions? If you just do it in chat, perhaps, or I can allow you to talk. There's only two of you. So, are there any questions? Okay, well, thank you everyone for attending today, and look out for our next webinar. Thank you. Goodbye now.